Your Honor, we are here today for a pretrial. There also is a bond violation in the file.
Yeah, there is.
Welcome back to another intense day inside Judge Simpson's courtroom. And this one's got it all. Suspicion, science, and a vape pen on trial. Today's hearing centers on Miss Haywood, a defendant accused of violating her bond by testing positive for alcohol. But here's the twist. She swears she hasn't touched a drop. The prosecution says the numbers don't lie, while the defense blames her vape. Yes, a nicotine vape. Over the next few minutes, you'll see legal logic clash with scientific confusion as Judge Simpson tries to figure out whether this woman deserves another chance or a trip to jail. Pay close attention to how calmly the judge unravels the story and how fast the excuses start stacking up. Was it a harmless misunderstanding or a reckless gamble with the court's trust? Stay locked in. The truth is about to surface.
Why don't we deal with that first?
Sure. So, as you can see in the bond violation report, Miss Haywood, for the first chunk of positive tests, did do an ETG test, which did come back negative for alcohol. She has, and that ETG should cover the period for those positive tests. Since then, she did have another positive test. I think the last one.
Which ones are you talking about the ETG covered?
She took the ETG on the 15th
Of March.
of March.
Right, but that doesn't cover, that might cover the 12th, the 13th, and you're saying the 14th.
Right.
Okay.
Right. Because the ETGs go back 72 hours from when she took them.
Yeah, I know how they work. Go ahead.
Judge Simpson wastes no time asserting control. You can almost feel the tension. The defense is stumbling through technical talk about ETG tests, while the judge already knows the system better than anyone in the room. That single line, "I know how they work," slices through the noise like a blade. It's a subtle warning. Don't test my patience with excuses. ETG tests detect alcohol metabolites up to 80 hours back. That means if the judge believes the science, the margin for error is small, dangerously small for the defendant. Viewers, here's the question. Do you think she's genuinely confused by the process, or is this a well-crafted dodge? Type your verdict below, because right now, that courtroom calm hides an approaching storm.
So she had another positive test, as the court can see. She was going to get another ETG done yesterday. However, she was at work and was unable to do so. I've spoken with Agent Mormon about it, and we haven't really come to a conclusion of what she thinks is triggering the positive test.
Oh, it's certainly not brushing your teeth.
No. She initially thought it was brushing her teeth. She now thinks it was a nicotine vape. That she was instructed to not blow 30 minutes before. She's been waiting 45 minutes and she hasn't had a positive test since changing that. So what I'm asking.
Why aren't I getting retest?
No. The reason why I did the retest the first couple of days was because I wasn't notified that the machine will actually tell me to retest. I thought that there was something that Mr. Mormon was going to have to reset, like off site. So that is my fault and my irresponsibility for that.
So I'd ask Judge if she could do it today.
Hold on. On the 16th, my problem with an ETG today is it doesn't tell me anything about the 16th.
Right, because of the 72 hours.
And so what I have before me right now is a positive test and no explanation for it.
Well, I suppose our explanation would be the vape issue. I mean, she maintains that she has not drank. She has this vape.
Here comes the turning point. The vape issue. It sounds ridiculous at first, yet it instantly shifts the courtroom's tone. Notice how the defense leans on uncertainty. I don't think it would. But even if it does, This hesitation is deadly in front of a judge. Simpson's face tells it all. Skepticism. In legal settings, theories need evidence, not guesses. The vape defense hinges on a wild possibility that aerosol residue could somehow mimic alcohol. But unless they've got lab data, this argument is dead on arrival. It's a masterclass in courtroom dynamics, when hard science meets desperate storytelling. Question for you: should judges ever give leniency for science I Googled last night?
She started using the vape when she was told at arraignment not to drink and not to consume marijuana.
Even if the vape has alcohol in it, which I don't think it would, but even if it does, she can't inhale or do anything with alcohol.
Yeah, I don't know why the vape would trigger the positive test. She's had continued positive at very small amounts. So that's our only explanation. I mean,
Here's the problem with that. The problem with that, even if you're talking a half an hour range, look at the very bottom of the report on the 16th. She submits a positive test at a 0.2, correct? There is then almost 20 minutes later, 18 minutes to be exact, there is a positive test. Again.
I don't have an explanation for it, Judge. I mean, if she was drinking, frankly, I don't know if we'd see that sharp reduction.
That's not a sharp reduction. That's a reduction.
I mean, going from 0.026 to 0.019 in 18 minutes, I don't know if it was alcohol.
Within the margin of error? Really, counsel?
Judge Simpson strikes again. Calm, factual, and surgical. He points out the reduction between two test results, but not enough to exonerate her. Here's where experience matters. A reduction in readings doesn't mean innocence. It can simply reflect body metabolism over time, yet the defense keeps framing it like proof. This exchange highlights the gap between courtroom drama and biochemical reality. Alcohol elimination follows predictable kinetics. It doesn't care about your vape or toothpaste. When Simpson presses for documentation, that's legal code for stop speculating. If you were in her shoes, would you have tested again to prove innocence or doubled down on denial?
I mean, she has consistently maintained that she has not drank alcohol. When she did have a positive test, she did an ETG and it was negative. So I think that explains that there's something else going on that she's consuming that we aren't aware of, that is triggering these positive tests.
And you need to bring me something that says a vape's going to do it. Because otherwise, what I have in front of me now, that she has a positive test. And then it's positive on the retest.
Yeah,
and moreover, if it's indeed true, she was instructed not to take the vape prior to testing.
Yeah, she has been waiting for a longer period since the positive test, and she hasn't had one since making that change.
Now we see a glimpse of hope. The defense claims no positive tests since changing vape habits. But legal viewers know correlation isn't causation. Judge Simpson's silence here says everything. He's letting them talk themselves into a corner. This scene underscores the power of self-control in a courtroom. A judge's restraint often speaks louder than argument. Viewers, remember this. Emotional calm under legal fire equals credibility. The defendant's story might hold some truth, but timing and proof will decide it. Is she a victim of faulty equipment or her own inconsistency?
Again, we don't know. I've had many conversations with Miss Haywood about if it was her toothpaste. I just think that, you know,
if she wants to go with it being her toothpaste, then
no, we've come to realize that we think it's the vape because since she's waited longer, she hasn't had any positive tests.
Where's the vape?
The vape's in my car at the moment.
It's in the car? All right. Then you're going to need to get some information on this vape. But right now, she's got a warrant out for arrest. She's here on an OWI-2. And I've got positive tests coming back. You've given me somewhat of an explanation for the other positive test, but I don't have an explanation for this one. It doesn't work that way. So is there somebody that can go out and get it?
She's here with her family. Her father can go get it.
Come go get it. It's in my purse. The key in the car. It's in my purse. It's in the car.
Because right now, like I said, she has a warrant for arrest. So she's going to have to go into custody until we can figure this out.
They briefed me. They told me that they called for an alteration in my results. That's exactly the reason why they told me to wait at least 30 minutes prior to taking my test. So during my debriefing, when they were giving me my sober link, they did tell me that the vape is capable of causing an alteration in my results. And that's why they said that they recommend to wait at least 30 minutes prior to taking the test. And the vape is the only thing that's altered in my normal routine. I never thought that it was any type of toothpaste or anything like that, which I told Mr. Mormon as well.
The report indicates you said something about it being toothpaste.
Mormon, he asked me the same thing, and I told him that I've always told him that I believe that it was my vape because that's the only thing that's altered in my daily license being released. And they also told me that the vape is the only thing that would alter it. But they told me that I had at least 30 minutes, and I had been waiting longer than that. And now that I no longer even use it, it's fine.
Finally, the defendant speaks, and her tone sells conviction. She explains her routine, defends her choices, and almost sounds reasonable, until you remember she's in court over multiple positives. Her words show honesty mixed with desperation. The courtroom energy shifts. The judge listens but doesn't soften. Legal fact: even truthful people violate conditions accidentally, but accountability is absolute. This is where empathy meets enforcement. Simpson's system doesn't run on feelings, it runs on compliance. Watching her recount this story, you can sense she wants understanding, not punishment. But the law doesn't grade intentions, it measures results.
I think that explains the positive test, frankly. I mean, with the first test positive,
She was again asked if it was the vape causing the positive test. She asked if it was the vape. She was then advised that it's her responsibility to check all products that she's using to see if they contain alcohol.
yeah,
And that's the absolute truth. That's the absolute part of the program.
I mean, I don't
It's
know.
her responsibility.
Right. And I think she knows that. We've had conversations about that. I also don't know if the vape, even if it doesn't contain alcohol, does something sober like device that positive test.
Excuse me?
I mean, maybe there's something in the smoke that malfunctions the sober link or something. I mean, I just don't know how
Oh,
she.
you want to go with that argument?
I don't know enough about the sober links, frankly, but I mean, I just don't understand. She has a positive test. She took the ETG. The ETG was negative. But we're still having the same issue. And as she said, the only thing that we can think of is this vape.
We'll wait for the vape, let you do your research, convince me that she should be released because right now she has a warrant. I won't send her back for processing at this point. Let's put her over in the jury box, get that in there, and then you bring me something, counsel.
Judge Simpson moves decisively. Warrant, custody, order. No hesitation. This is the moment when courtroom sympathy evaporates into procedure. For viewers, this is justice stripped to its bones. Impartial, mechanical, and necessary. The defense tried to humanize the defendant. The judge re-anchors to the law. When he orders custody until proof appears, that's not cruelty. It's containment. The takeaway? In legal systems, evidence trumps emotion every single time. Ask yourself, would leniency here encourage accountability or invite chaos?
You can consider yourself in custody. Go with my bailiff. She's going to seat you in the jury box, man. Court does recall the case of People versus Unique Haywood.
Oh, yeah.
Assistant Prosecuting Attorney Morgan Burrows on behalf of the people.
Good afternoon. This is the Public Defender Lauren Perny on behalf of Ms. Haywood. Ms. Haywood, please state your name for the record.
Unique Haywood.
Is there anything else you want to say regarding these bond violations?
Your Honor, I did, thank you for the opportunity to speak with my client. She, at this time, does not admit to consuming alcohol. We did, off the record, speak about the possibility of alcohol from a vape. She wants the court to know she takes full responsibility for using a vape. She reiterated to me she didn't know that it consumed alcohol. She does take responsibility for.
Okay. Can I just, I'll let you go on, but can you just stop right there for a moment? Because there's a number of different problems with this whole argument. Some of which have to do with sort of the global picture of things. With the number of people that vape, I would be seeing this all of the time if it were that vape. That's the first thing. Second thing is, and I certainly will let you continue, but one of the things that's bothering me is the issue isn't necessarily drinking. She cannot consume any product or in any way consume or ingest any alcohol. Those are the rules of the program. And I know it's explained to you. It's explained to you in excruciating detail. She is also, upon a positive test, for whatever the reason, is supposed to retest. She did not retest. She's not following any of the rules of the program. She did not retest after her initial one on the 12th, the one on the 13th, she didn't retest. On the 14th, she didn't retest. On the 16th, she didn't retest. Oddly, then on the 16th, there's a positive test. There are actually two. She does retest. She didn't retest immediately, but she retested and then contacted community corrections. She's the one, according to this, that brings up the vape. According to what was said to me before, that they were then supposed to wait, say, a half an hour or so before she tested if that was it, but they did remind her that she's responsible. She then, 45 minutes after that phone call, submits another test. It comes back positive again. So I'm having a little bit of a difficulty believing that that's it. I also will say, and again, I'll let you continue on, that had it been the vape, she received the unit on March 9th.
Simpson's patience finally cracks. His logic is bulletproof. If the vape were truly the cause, everyone using one would face the same false positives. He's invoking pattern logic, a judge's intuition rooted in probability. What's fascinating here is how calmly he dismantles the defense argument point by point, exposing how implausible it sounds under scrutiny. It's a clinic in judicial reasoning. For viewers, this part shows why courtroom truth isn't emotional but mathematical. Judges live in the realm of patterns, not pity. Comment below. Do you think this defense ever had a chance, or was it doomed the moment vape entered the conversation?
Which means, and she did a compliant test on March 9th. That means then on March 10th, March 11th, I would have had positive tests. I don't. I don't have, unless somebody's just vapes occasionally.
Hold on. The last 2 points I wanted to make, Your Honor, she does take responsibility for not retesting. She says she should have been more diligent at looking at the device after she tested. As for your last point about when she got the device, when she started testing positive, she normally does not vape. She started using the vape after she got the device. So that's why when she says she hasn't, that's the only thing that she thinks it is because that's the only thing she's changed out of her normal routine from when she got the device to now. And that's all I wanted to say.
Then I still would have had a positive test on 10 or 11, the 10th and the 11th, if that were indeed the case.
When did you start vaping? I purchased my vape on the 12th.
Yeah, of course.
I did. When did you start using it? I started using it, I used it on the 12th that morning. Okay.
Anything else?
I mean, I would reiterate my request to the honor to have her do an ETG today, switch her to a scram tether, and adjourn this out to see if she continues having tests in order her not to use any nicotine or vaping products.
Does she want a hearing on this, or is she admitting to the violation? I mean, I'm not sure what you're doing here. I mean, if she does neither, I'm going to set it for a hearing. So I mean, she doesn't have to say. But
Your Honor, let's set it for a hearing, please.
set this for a bond violation hearing. My normal date would be the 3rd, but since she may likely be in custody, I'll set this for March 27th, 2024. That's a special time at 9 a.m. for the bond violation hearing. What is the alleged BAC in this case? I see that there's a prior.
Yes, Your Honor. In this case, the alleged BAC is a 0.192, and there was a crash, a single motor vehicle crash.
I didn't do the arraignment, so how long?
She was on probation for operating while visually impaired out of the 34th district. That conviction entered on August 3rd of 2023. The offense date on this is January 22nd, 2024.
Got it. All right, I'll set a bond hearing for that March 27, 2024 date at 9 a.m. Defendant's bond is reset. Your bond is going to be $25,000. I'll give a 10% privilege on that. However, prior to any release, if she posts that bond, she's to be placed on a scram tether prior to her release. Defendant is remanded.
Thank you.
Case closed. Miss Haywood's bond reset at $25,000 with a 10% privilege. Scram tether ordered, remanded into custody. Judge Simpson delivers a textbook conclusion. Fair, firm, and fully procedural. This ruling reflects the core of modern courtroom accountability. Leniency ends where repeated uncertainty begins. Whether or not the vape truly caused false positives, the defendant's failure to follow retest rules sealed her outcome. For anyone watching, this is a reminder that legal systems reward consistency, not excuses. The vape debate might sound modern, but the principle is ancient. Responsibility never vapes away. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.